Dr. Mr. Xiaolin Dang. He's a partner of Beijing Sanyou Intellectual Property Agency. He joined the agency in 1999. He has both engineering and legal backgrounds and has received privileged qualifications in China, including lawyer's qualifications, patent attorney qualification, and trademark attorney qualification. He also received an LLM degree from the U.S. and passed the patent bar for USPTO. So Mr. Dang has consulted and received trust from many of his clients, including domestic and international corporations, as well as multinational groups. His wording area covers patent cases, including protection plan and filing strategies of technology, drafting of patent applications in Chinese and English or both, prosecution of patent applications, patent re-examination, patent invalidation, patent administrative litigation, and patent infringement litigation, as well as other legal cases related to trademark, copyright, and unfair competition. So will you please welcome Mr. Dang? Okay, we're getting started with our workshop. Will you please keep down with that? Thank you.
Thank you for the introduction. I think in this morning we have a lot of calls, so I recommend that we have a relax to see the 5-minute video, which is our first profile. So please.
Li founded China's first private patent law firm, Beijing Sanyou.
Very specific
Over the last 25 years, China's intellectual property cause has developed with breathtaking speed. And today, Beijing Sanyou, with over 200 professionals and clients across the globe, remains one of China's IP pioneers. One of our guiding principles is to create a brand that will last 100 years. This signifies our long-term commitment to providing our customers a comprehensive range of protection and intellectual property. We believe that our clients respect the quality of our service, our energy, our efficiency, and our loyalty. We place the highest value on building a team with professionalism, excellent knowledge, attention to detail, and practical experience. Our team includes experts from every major field, including electronics, communications, computing, physics, engineering, chemistry, biology, pharmaceuticals, and many others. Meanwhile, our patent agents, the litigation team, validations, have led with consistent success in court review. At the heart of our company infrastructure is an efficient and comprehensive digital information management system, which enables us to achieve the highest levels of accuracy and safety working with the intellectual property assets of our clients. In 2011, we became the first IP law firm in China to file 100% of our news agent applications electronically. We received an official award from the Chinese State Intellectual Property Office in recognition of this achievement. Our firm also obtained the ISO 9001 Quality Management Certification in 2011, reflecting our consistent pursuit of quality. Innovation, hard work, having an open mind, and the desire to improve, these are the values that bind us together and inspire us to move forward. Our firm also understands that private enterprises have a social responsibility. We have for many years engaged in projects that serve the greater needs of society. We at Beijing Sanyou strive to sustain and enhance our traditions of self-improvement, innovation, effective cooperation with our international partners, and above all, our unparalleled dedication to our clients. Many years to come.
These are still problems we will address it.
皆様が時代保護のために頑張ります。モデルモデル、완벽하게해내야됩니다。
三有理共舞未来。
Yes, thank you everyone. During the last time, since we have a limited time, so maybe some slides I will see quickly. So I will focus on some main issues. Here, the main topic is how to obtain and maintain a high quality patent in China. Here is the table of content. We will discuss about what is strong patent in China and some defects, including absolute defects and relative defects. And last, we will discuss how to define the patent in China. So, what is strong patent? Here, we can see there are three aspects to evaluate whether the patent is strong or weak. So, strong means the patentability is stable against a challenge, and then that's not enough. It's broad enough to cover your competitor's product or method, and then it should be commercially valuable because you maybe use your own technology, not to license others. So, how to make a patent strong? We will examine that there are some grounds in validation procedure that others could use to challenge your patent, and also what kind of amendment during prosecution or during invalidation that you can make. Here are some main grounds for invalidation requests that when you have your patent issued, you can sue others, but there will be a challenge that others may file invalidation requests against your patent with some grounds. Here, we divided them into two categories. For absolute defects, usually the defect lies in the patent document itself. There's no meaning. Such as the claim is unclear, or claim is not supported by the description that is a support issue. In the United States, usually the court or the examiner will not raise such issue. But in China, is quite often raised by the examiner or by the petitioner during the validation procedure, and also insufficient disclosure and original amendment. So original amendment is also quite unique in China compared to the situation in the United States. For relative defect, usually they relate to novelty and inventive issue. For unclear ground, the requirement that the claim should be clear, consistent, and unambiguous to define the scope of the claim. So here we see an example. In one case, decided in 2012, the claim says that the second delay device has a delay time greater than 20 nanoseconds. This rule is very clear. Anyway, the court found claim 1 is unclear because there is no precedent for the second delay device. Because claim 6 refers to claim 1. There is no any definition about the second delay device. Maybe in the description it's very clear, but anyway, the claim is not clear. So that is the point. For non-support issue, that the claim should define a solution that is can be derived from the disclosed embodiment. That means you need to contribute to the public with your technology described in the description, and then you can get something back in the claim that you claim a protection scope. So what you claim should be less, at least equal or less than what you have disclosed or contributed. So here, in this case, in claim 27, which is very long, that there are two sentences, or there are two features. The first feature is that the first signal is controlled by the regulation of a circuit based on reference signal. And then the second signal will determine the reference signal. That is the technology. But anyway, they want to claim a feature described in claim 27, which said the first signal changed according to the second signal. This looks like simple or easy to understand. Anyway, in the embodiment, there is no clear description about the relationship between the first signal and also the second signal. And there is no such description. The patentee argued that an ordinary skill would derive the feature by the description in the embodiment. In the embodiment, because they said the first signal has some relationship with the reference signal, and also the second signal has also a relationship with the reference signal. So through the reference signal, there will be a relationship very clear between the first and the second signals. Anyway, the court found that should be a deduction. Anyway, the deduction should be based on the ordinary skill in the art, whether ordinary skill in the art could understand or not. The board, during the validation procedure, both said it is not easy for ordinary skill in the art to derive the feature based on the description. And the court finally agreed with the board that such logical deduction from the embodiment cannot be justified unless evidence is provided. So you just have some logical description without any evidence. So finally, the patentee failed. Also, non-support issue. This is a very tricky case. That the problem that in the Chinese claim 1, the patentee or the attorney for patentee make an error in translation. The original language of claim 1 is very clear, but in translation they make a mistake. So describe a different feature from the original language. Anyway, they made a correct translation in the embodiment. So there will be an inconsistency between the Chinese claim 1 and the Chinese embodiment. So we use that, we take that as a defect and file the invalidation request. Because there is no kind of correspondence between claim 1 and embodiment, finally the board supporting us invalidated that case. That also gives us teaching us a lesson. Maybe the technology is very good and described in the original language is very good, but in some countries, maybe in China in Chinese, in Japan in Japanese, maybe the translation will keep your technology out, not what it like. Insufficient disclosure, usually the description should include sufficiently detailed embodiment that could enable a person's view in art to indicate their invention. That means you need to describe enough technical information that enable others to use your technology. You just not give an idea, but you need to teach how to use it. In this case, independent claim 2, claim a folding device, and it contains a feature that a folding mechanism, so as to fold the number 3. Anyway, in the specification, the number 3, there is no specific description, and also they rely on the folding of number 3 to another number 19. Anyway, there is no further detailed description about the number 19. So finally, the board considered there is no sufficient disclosure about the technology. You just give some the name of numbers, but there is no detailed structure of the number. For operational amendment, that is, after filing any amendment cannot go beyond the original disclosure. That is, you just limited yourself in what you have disclosed. And to remind that the standard in the United States is quite different from that in China. In US, you have quite flexible ability to make an amendment. If your amended claim or amended feature is supported by the embodiment. But in China, the standard is very, very strict. Usually, you need a literal description basis. That is, what you described literally. Then you can rely on those descriptions. You cannot regeneralize something. There are several scenarios that generalization based on embodiment is not wrong. So during at the time of filing, what kind of feature you have obtained from the embodiment, and you can use those language. If you have described several embodiments, but you did not generalize like a general feature to cover those, later you cannot generalize. And also new combination of features in different embodiments. Maybe a feature A in example A is very good. Feature B in example 2 is very good. So you suddenly find that this is a good way to combine feature A and B in one example. And they are possible. Technically, it's possible. Anyway, if there is no such description, it's not wrong. Some others. Here is one case that the original claim said a filtering device including a lot of elements. And they suddenly find that after filing, they found, oh, that describes so many. A lot of elements are not necessary in my invention. Because the scope of the claim depends on the features you write in your claim. If you write more features, then your scope will be narrow because others need to use all the features in claim to infringe your patents. If you have lots of features, then the scope will be narrow. So suddenly they found some elements are not necessary, so they want to cancel them. So they amend the claim, like the lower part. the filtering device including just 3 elements. And because the board found you did not describe a filtering device include only 3 elements without others. That is not your invention. So the court supported the board and the family invalidated this case. I would say in this case, from the inventor side, the inventor did a good job. He invented the invention, gave the detailed information, but maybe during drafting, the attorney did not understand the invention correctly. Here, relationship between the inventor, patent team, and also patent firm, they need to cooperate with each other. Usually, this is for a company with an IP team. For startups, maybe the startup should be take both positions, inventor and patent team, and communicate with the patent firm. Let us skip this to save time, so we can come down to the substantive matters. Here are some suggestions on how to avoid those problems we described. To avoid mistranslation, there's a difference between the PCT route entering into Chinese state and also direct filing in China through Paris Convention. If you file a PC application, then later you have the right to enter into Chinese stage. In that case, if your Chinese translation contains some error or mistake, you can correct it during prosecution based on your PCT international version. But if you file a direct Chinese application based on a US priority, then even there's some mistake in translation, you will not have the opportunity to make a correction. Here, for novelty and the inventive issue, there's a change in Chinese patent law about the novelty standard. In the old law, that before 2009, October 1st, the prior publication disclosure worldwide will count. But for prior use disclosure only within China mainland will count as a prior art. So for example, you invented a new product and you sold in the United States, but you did not publish the information of your product in any publication, like a magazine, catalog, online, or something. Based on the old Chinese law, that such behavior is a disclosure in the United States, but not a disclosure in China. So you still have the right to file a Chinese application, Chinese patent application in China, and without any effect by your previous behavior in the United States. Anyway, with the change in Chinese patent law, that any application filed on or after 2009, October 1st, those kind of behavior in the United States will be considered as prior in China. So be careful. In the past, you are safe to do something in the United States, but now, if somebody can show the evidence that this product has been used or sold in the United States, that will also destroy the novelty in a later filed Chinese application. Here, to avoid the novelty and inventive issue, we found that during drafting is very important to do something. First is the prior search during drafting, and also the priority claim if you have a US priority. And also, when you draft a claim, it's better to use a reasonable layout of independent claim and dependent claim. That means you have a very broad independent claim, and you have greatly narrowed down dependent claims, etc. So the structure of a claim scope is just like the cross section of an onion. When you cut onion, you see a lot of circles. So in the middle, there's only one point. That is the narrowest scope, which is your detailed drawing. For prior search during drafting, I think it's necessary to make a complete prior search during drafting so as to draft claim distinctive from the prior with a suitable scope and also avoid any difficulty in amendment later. Because, for example, you describe your invention in a general way and you understand the details. But for some details of the structure, you did not exactly point them out in the description. But later, during prosecution, if the examiner find a very close prior and say they are quite similar, you understand that you have difference, very significant difference in your product from the prior. But anyway, those differences you did not exactly point out, so you cannot rely on the difference in your product. Here is an example that is Tsinghua University case. They during the claim 1 claims a future material containing a feature of fiber, but without definition of the shape. During prosecution, Tsinghua mentioned that the shape of fiber is a bench-ness shape, but did not write it into claim 1. And then that case had been granted because the examiner did not find very close prior. But after grant, somebody challenged the patentability in an evaluation procedure. They found prior document 4 disclose a future material containing a feature of fiber. And they found that according to the wording in claim 1, they are the same. So Tsinghua argued that the shape are different, but the shape of fiber in document 4 is a bowl shape rather than a bench-ness shape in the patent. And the board found, also the court affirmed that the difference, that the bench-ness shape argued by Tsinghua is not written in claim 1, but only in the specification. And claim 1 does not have novelty over document 4. So that is a pity. The user did a good job. Anyway, in the drafting, there is some mistake. Finally killed the case. For priority claim, this is the UK case does show that sometimes you have to, if you claim a priority, like for example, US filing, then it's better to keep all of the US filing description in your own description, in your Chinese description, and then claim the same scope as that in the US. This case that they claim the priority, but in their own case, in their own application, they add some new matters not described in the priority document. So finally they failed. Here are some tips for drafting. I think those should be the tasks of the patent agents or patent attorneys. In China, we also have file record estoppel. Estoppel is quite it's a common issue in the United States and also in China. That when you during prosecution, you want your application to issue, so you make some argument. Then later, you cannot make another different argument against your previous argument. Here, this is not a case, just an example. In examination, claim 1 and its dependent claim 2 are deemed as lacking inventive step over prior art. So in the response to the objection, the applicant amended claim 1 by incorporating a feature we call it in the description. In addition to arguing the novelty added feature is not disclosed by prior art, the applicant also state that the feature in claim 2 is substantially different from the counterpart in the prior art. So during the prosecution, they argued 2 points. The first point is the new method, the new feature they introduced from the beginning claim. The other is that the amendment. Anyway, I think the exact point for the argument should be the new added feature, not the feature already existed in claim 2. During litigation, it's unfortunately for them that there's a difference just on the feature already described in claim 2. They move it into claim 1. So they are it's able to argue that that feature could be changed during under the doctrine of equivalence. Sorry, I skipped some slides quickly due to the limitation of the time. Later, I will provide the document of my PPT document to the association. I don't know where to download. Maybe you can contact here is how to define the patent during invalidation. The first part that how to obtain a strong patent to avoid some defects. And here we have a patent, so somebody challenged it. Because the patent exists there, we cannot change that. So how to define it? There are 3 aspects. There are some limited amendments, and also we can make some defense against prior challenge during the procedure. And the third is a special measure to strengthen the patent. The amendment in China after the post-grant procedure is very limited. There are only 2 allowable ways. One is the deletion of the claim or technical solution. The other is a combination of different parallel claims. It's very limited. Here it is that if not necessary, it's not advisable to make an amendment to combine 2 claims together or cancel claim. That would result in resolvable later. So defense, here are some tips to defend your patent to attack the other's evidence. First is whether the other's prior evidence is authenticity, and whether the translation of the foreign prior is correct, and some others. Maybe just 1 minute. Yeah. Here's one example that investigates the background of prior art. This case handled that is quite similar in the prior art that prior disclosed the exact same invention to us, but without mention of some feature. Those features usually will be considered as a common knowledge or some simple feature. Anyway, after investigation, I found that in those prior art, those unmentioned features are quite different from the feature in our patent. Here are some special measures to strengthen the patent that if you want to sue others, and you need to make sure that your patent is strong. Maybe you have found that there is a very dangerous evidence against your patent. So in that case, we can have a special measure that you can file validation request against yourself with that evidence, just to test whether your patent is stable in facing that challenge. Then you can rely on the result. Because in China, the same ground and the same evidence or combination of evidence cannot be used twice It's the first time the decision has been made. So it's also possible that you use a straw man to file demolition request against your patent just to test the patentability. And in that situation, I think that the straw man will not attack your patent heavily as your competitor will do. Thank you for your attention, and I'm sorry for the late. Here's our contact information. Okay, I think we have a few minutes more, and if you have a question, I'm very happy to hear today. Yeah. Sorry, I took your right. Because the time here is quite limited, so if you have further questions, we can go upstairs to discuss later. Thank you. We need a hello room.